Hello again, it's Dan with the Law Offices of Daniel Hunt, and in today's video we're going to be discussing special needs trusts and what they are. What is a special needs trust? It's a type of trust that allows a beneficiary to retain their government benefits or subsidies while still being able to get an inheritance, typically from their parents. There are two types of special needs trust: first party and third party special needs trust. The first party special needs trust is funded with the assets of the person who has created the trust. Third party special needs trusts are funded with others' assets that do not belong to the beneficiary of the trust. Third party trusts are preferable if we're able to set those up because there is no payback clause when the beneficiary passes away. A first party trust, the first person in line to get any money from the trust that is left after the beneficiary passes away is the government. So why would one create a special needs trust? That's because anybody who's receiving government benefits like SSI or Medi-Cal, if they receive an inheritance that is more than $2,000, they're going to lose their eligibility for their Medi-Cal benefits or their SSI. A special needs trust set up by typically the parents that is funded with their funds will be able to make it so that they can receive that inheritance and still remain eligible for their Medi-Cal or SSI. Often folks are faced with a difficult decision whether to receive the inheritance or to continue receiving their Medi-Cal or SSI benefits. As I mentioned before, there's a $2,000 threshold for those assets that they can retain while still receiving Medi-Cal and SSI. With a special needs trust, any funds that are put into that special needs trust do not count towards that asset threshold, meaning they can receive an inheritance and still retain their benefits from SSI or Medi-Cal. So here's how a special needs trust works. Typically the parents will set up this irrevocable trust while they're still alive. Generally, this is funded when they pass away with assets from their revocable trust. An independent trustee is appointed that manages the trust assets for the beneficiary as long as they're alive or until the assets run out. Once the assets run out, the trust is then dissolved, or if the beneficiary does pass away, any assets remaining are left to the beneficiaries that have been designated by the folks who created the trust. Typically that's you, the parents. So most people will name themselves as the initial trustees of this special needs trust if they do end up funding it while they're still alive. But in most cases, the successor trustees are the ones who will actually be taking the inheritance from the revocable trust, the main trust, and then administering that for the beneficiary. This can be a sibling or a professional fiduciary, but it's important that they know the rules so that they don't get tripped up on that and cause a lapse in Medi-Cal or SSI coverage for that beneficiary. So when should a special needs trust be set up? The answer to that is now. That's because these third-party special needs trusts must be set up prior to your death so that the inheritance can flow through into it. If it's set up after your death, then it's going to be a first-party SNT, and that once again requires payback first and foremost to the government for any benefits that that beneficiary received. The third-party special needs trust does not require that payback. It's a huge advantage. As far as the cost for a special needs trust, here at our firm, we charge about $1,500 to create these documents. That makes them slightly less than a revocable trust, which often people have both created for their estate plan to make sure that all their goals are carried out. So we hope that you found this video helpful for you if you are looking into creating a special needs trust. And if you have any questions, please don't hesitate to contact us here at the Law Offices of Daniel Hunt. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.